Hey everyone, Michael Warwick here. I'm here with attorney Jay Davis from James W. Davis & Associates. You can see Jay weekly on It's the Law Wednesday nights during our 6 o'clock show, but for now we're talking about a case that went all the way up to the Georgia Supreme Court. It's the case of Jadarius Meadows, Jay.
That's
your
right.
client.
My case, my client.
Tried for murder in 2015. Let's start there with that case and what the judge decided in that case.
Well, the things that led up to that case, there were some things that were going on that sort of created some sort of acrimony in the courtroom.
Yeah.
And that was, I was trying to get a speedy trial. It'd been a year and a half, he'd been in jail without going to trial. There were two co-defendants. No evidence against my client whatsoever except for what the co-defendants may say. And of course, they're still got the right to plead the fifth, so there needs to have something going on with these co-defendants. Nothing was happening. The only thing in all of the videos with the co-defendants never brought up my client's name until it was brought to them by the police and sort of allowed them a way to mitigate their own culpability by incriminating my client. So we were having some conflict at the beginning with what the evidence actually showed. And I was willing in the first continuance to allow them to continue so they could try the other people. But after a period of time when they're not trying the other two co-defendants, my client's now they're knowing that he's third one down and is a year and a half in jail. I started making an application to the judge, and the judge was tending to agree with me. So we were about to go to a speedy trial, and then bam, 10 days, I was put back on the calendar we were taken off of, 10 days to get ready for a murder trial. We're ready to go. Made motions for late evidence, not to give us any late evidence as had happened in the past. They again, 3 days into trial, gave us late evidence. So we were the whole thing was very contentious between us and the prosecution. So that was sort of part of it, and we believe, and I think the judge at some point thought that that may have reflected into the jury dynamics as well.
Okay.
Because it became a very hostile case because we felt we were not being tried in a just way. And I felt personally as an attorney that my client was being attacked because of the way I had represented his rights. And that made me very personally involved in this case.
So it was contentious.
All of those things were happening throughout the 4 days of trial before the jury even goes back.
Yeah, so it was contentious between the defense and the prosecution. That sort of boils over, as you're saying, into the jurors' room where they're deliberating.
Right.
What happens from there?
From there, the jury goes back. They're out for a period of time. One lady comes back, one note comes back saying one of the jurors wanted to be excused. And when questioned, she was brought out to be questioned by the judge, and her reasoning was that she wasn't in her right mind and she didn't want to keep having to justify her opinion over and over again, which is what happens in deliberations in a jury room. And so the judge asked for input from the prosecution and the defense. Neither of us objected. Neither of us questioned the juror. We both agreed to her being dismissed and being replaced by one of the alternates, which is what happened. Now, from a legal sense, when she's replaced, then the jury deliberations have to begin anew. They're not continuing where they were going on without this one individual. They have to start all over again. And at some point, they had already gone on a smoke break for 20 minutes, and they ate while they were deliberating. So in the time that this juror was removed, and also they had requested a video that was entered into evidence, it took 30 minutes for the court personnel to find a player for them to watch the video that they requested. So that took up time, and all of that took place in right at 3 hours. So our position is this is not long enough for a jury to deliberate. It started all over after 1, so who knows if that's reduced to 2 hours, 2 hours and 15 minutes, something less than 3 hours. And they waited for some amount of time. They could deliberate while they're waiting on the video machine, but there was a period of time to get the video machine and watch some video. They were still out. And the judge was calling to get progress, and when the jury came out, he asked them if they were making progress. The foreperson said yes. And there were two, there was at least one that I heard, but it was said that there were 2 of the other jury members that hollered out no. So there was some division as to whether or not they were making progress. Nobody had anything about safety, said anything about safety, mentioned anything about safety. And the jurors were sent back to continue deliberation. Shortly after that, the judge came in that a bailiff who was standing outside the jury room door had come to him and said, they sound like they're getting so bad in there that I want to have to go in. Now, he left the door, went to the judge's chambers to make this comment. So our position is it wasn't so bad you had to go in. It wasn't even so bad you couldn't leave the door.
Because he went and spoke to the judge.
He went and spoke to the judge.